Good morning, Council, and welcome to this morning's oral arguments before the Kansas Court of Appeals. We just have one case before us with this panel this morning. I am presiding Judge Catherine Gardner, and with me is Judge Kim Schroeder, who's been on the court since 2013, and Judge Richard Walker, who is a retired district court judge from around the Newton, Kansas area and has participated in our senior judges program, sitting with the Kansas Court of Appeals for many years. So welcome to them. I will be keeping track of time. This is a 15-minute oral argument, and so we'll go ahead and get started. I'll call the case of 121438 in the matter of the protest of Arciterra BP, Olathe, in Johnson County, Kansas. So I'll go ahead and take your appearances, please.
The appellant Board of Commissioners at Johnson County, Kansas appears by and through Assistant County Counselor Ryan Carpenter, Judge Gardner.
Thank you.
And members of the court, I represent Arciterra. My name is Linda Terrell, and I'm an attorney in Overland Park, Kansas with the law firm Property Tax Law Firm.
Thank you both. Mr. Carpenter, would you like any rebuttal time?
Yes, Judge Gardner, the county would respectfully request 5 minutes of rebuttal time if it pleases the court.
Okay, very good. You may do that and you may begin.
Okay, judges, thank you for your time today. This is a single freestanding single tenant property appeal, which operates as the Bass Pro Shops in Olathe, Kansas. It's 130,988 square feet of net leasable area. The county appears before you today appealing this matter from the Board of Tax Appeals based on the county's belief that BOTA erroneously interpreted and applied the law, and that the substantial evidence does not support the finding of the Board of Tax Appeals at that level. In its full and complete decision, the Board of Tax Appeals stated that after review of the record, board finds no evidence that Keller's market rental rate analysis included adjustments to build-to-suit leases to comply with the pre-mandate. This language in the Board of Tax Appeals decision, in the county's opinion, unduly extends the holding in the pre case, which really said that you cannot use contract rents and that you must go to the market in order to value a property under generally accepted appraisal standards.
But wasn't the bottom line in Prebe that you cannot use build-to-suit leases for determining fair market value in these cases without adjustments? And it referred to a treatise. It really didn't state out what those adjustments would be. It pretty much said, don't use first-generation build-to-suit leases, did it not?
In response to that, Judge Gardner, the county believes that the language referring to build-to-suit leases is dicta, because the language says, consequently, we hold that rental rates contained in or reflected by commercial build-to-suit leases are not reflective of market conditions and may not be utilized for purposes of the income approach or sales comparison approach for ad valorem tax purposes in Kansas without disentanglement by adjustments that is beyond the scope of this appeal. The county believes that beyond the scope of the appeal means that they didn't provide any guidance or suggest what those disentanglements should be. Also,
well, simply cited to a treatise that suppose, I presume, would state what those adjustments would be as necessary for disentanglement.
And in regards to the disentanglement issue, the county would state that certain states that were cited in Prebe, specifically the Rite Aid cases, have been overturned in New York, as some jurisdictions has determined that build-to-suit is the market, and the market disentanglements would not be necessary if the per the Appraisal Institute, sometimes the market rent can equal the contract rent if certain conditions are met. And in this case, Mr. Keller, the county's witness, analyzed the rents that he used, determined that those essentially represented market rents, took the normal market adjustments, build date, quality, size, and applied those. And that's how he came up with his rental income. So he made a determination.
I'm having a hard time understanding market rents in this relationship when the rent paid by the tenant at the equals purchase of the property at the end of the lease for $10. So how is that rent that you're calling rent not a payment for buying the property with financing and all the other entanglements that go with buying a property?
Judge Schroeder, this property was built with Star Bonds and it was sold to Arciterra. So if I followed the history correctly, Arciterra is the new landlord, and that essentially the rent is that they are charging to Bass Pro is to cover the amount of their investment. Usually at the end of these leases, there is not a $10 purchase option. This one is certainly unique, but it's the county's position and the county's retained expert's position, Tim Keller, that that it's no different than any other property where the rent charge, i.e. the market rent, is to cover the cost of construction and some marginal profit returned to the investor.
All right, you said it's unusual for a $10 provision at the end of the contract. What's normal?
Normally, if there is a purchase price, Judge Schroeder, it would be much higher than $10. This is unique in the market in that regard.
So doesn't that affect the market value of the rent?
It does to a certain extent, but there are other properties that the county has seen that have nominal purchases at the end. For example, a sporting goods store in Leawood, Kansas, where sometimes these companies do not want to be their own landlords, for lack of a better term, where they prefer to lease the property. So sometimes these options are not executed, even if they have a nominal purchase price at the completion of the lease.
Thank you.
Answer your question.
Yeah, I understand what you're saying. I just know as a landlord, when you lease something for X number of dollars a month, at the end of the lease term, you still own the property. In this situation, the landlord loses the property if Bass Pro pays $10.
If Bass Pro decides to exercise that option, which we will not know until that option comes to fruition.
Well, financially, it would be a foolish decision not to.
Wasn't there testimony that they anticipated they would exercise that option?
I believe Mr. Rice said they contemplated doing that, Judge Gardner. The only thing is when you buy these properties, then all the maintenance, all the refurbishments becomes your responsibility. And a lot of times these companies, even if there's a nominal just back price or purchase price at the end, would prefer to rent for certain, be it liability perspective, be it maintenance perspective, they would prefer to rent instead of exercising that optional even at a nominal price. And we really won't know. Obviously, we won't know what Bass Pro decides to do until that option becomes available to them. Comps used by Mr. Keller did not have such purchase options at the end at such a nominal rate.
It's curious that it seems like the county's valuation essentially doubled from 2015 to 2016 for this property. Is that correct?
Well, yes, that's correct. Can't change the facts. That was based up on a study of sales by the county appraiser at the time, who determined that based upon sales of single freestanding single tenant properties, that he believed at the time that the county had chronically been undervaluing certain properties. And at that time, the county appraiser utilized Valbridge and Associates, an appraisal firm in Overland Park, Kansas, to do a big box study. Based upon that study, the valuations, a lot of cases, yes, Judge Gardner, increased significantly. There's no doubt about that. And certainly as an attorney before you, if I had my druthers, they would not have, I would not be standing before you arguing a increase of twofold, but the facts are what they are. The appraiser who was charged with valuing the property at fair market value believed that we had lagged for some time in fair market value when it came to these properties, made the determination to increase the valuation, and that's where we are today.
Does Mr. Keller's approach accept or reject the fee simple analysis? That
Well,
fair market value is measured by the fee simple value of the property, or the fee simple interest.
Mr. Keller does believe that he valued the property in fee simple interest. As stated in the brief and in county's closing, that remains some issue. The Preeb case appears to be using, or is using, the definition of fee simple by the Appraisal Institute. And the Appraisal Institute in its text differentiates between a fee simple and a leased fee. All of us on this call who have taken property law realize that there is no such thing as a leased fee interest in property law. We are also taught the legal definition of fee simple in property law, which is different than the Appraisal Institute's definition, which purports that fee simple doesn't include any encumbrances and considers a lease an encumbrance, and then it becomes a lease fee. Well, as we know, all of our individual properties, our homes or whatnot, there are encumbrances. Encumbrances can detract, or they can detract to the value, they can add to value, or be neutral to value. We all have easements on our property for utilities. That doesn't destroy the fact that we own in fee simple. And Preeb essentially created a new definition of fee simple, and there's no definition as set forth in the county's brief of what fee simple is. Given the absence of the definition of a specific definition of fee simple in the statutes, you have to give peculiar definitions of which fee simple is, and you revert back to the Black's Law Dictionary definition of fee simple. That's the county's position, Judge Gardner.
I have a question. If I understand the record correctly, the county's closing argument with Boda was not filed with them and not considered. Does that create a procedural problem for the county on appeal?
Well, Judge Schroeder, I think in preparation for this, the county moved for on January 6, 2020 to amend the record before the court to include the county's closing arguments. And the court granted that on January 22nd, 2020. And that was based upon the timestamp and the filing of, I have it in front of me, I'm sorry. It's sometimes have to look at the paper and can't look directly at you. That shows filed on April 15th, 2019 and sent to appeals and received by Ms. Darrell on this list.
I understand our court has allowed it to be filed as part of the record, but it wasn't filed in Boda's record or considered by Boda on its denial of your valuation request. Is that correct?
I thought it had been, Your Honor. I'm not 100% certain Ms. Myers filed that, my predecessor in the job, Your Honor.
Well, if Boda didn't consider your closing argument, is that a procedural flaw for us to proceed with your claims on appeal?
I don't think so, because all indications based on what it appears to be on the timestamp or the file stamp is that Ms. Myers did file it with the Board of Tax Appeals. I do not know where the breakdown came, on whether it was considered. It does highlight all of the issues that the appellee suggests that the county waives. The county does believe that the Board of Tax Appeals did receive it, and struggles to understand where that position came from, Your Honor. I'm sorry, Judge Schroeder. I didn't mean to call you Your Honor.
That's fine.
You have about 1 minute, Mr. Carpenter.
You know, you always think these things are going to go quickly. Essentially, we think the county thinks there are some issues with the hypothetical leased fee. It's not taught anywhere in any appraisal institute. Mr. Mayor is the only appraiser that uses it at this time. That is the value that the Board of Tax Appeals relied on. The county believes that its values offered are the ones that comply with generally accepted appraisal practice. There was no motion to move for a directed verdict. The county believes it met its proof prima facie case, and we respectfully request its value to be upheld. And I think I heard the beep, Judge Gardner.
No, that was from my other computer, so I apologize.
Oh, okay.
It has no bearing. I'm not sure how to turn it off.
That's okay.
It's useful. Don't turn it off.
Very timely.
I had to figure out how to turn my phone all the way down at my office phone this morning. So I think I'm Judge Gardner. And
yes, it was very timely. So thank you for your argument. Ms. Terrell, 15 minutes.
Thank you. I'm not saving any time, obviously. I would like to preference my argument, though, by stating that my law firm has been practicing remotely since February of 2020. And so I have dubbed this as one of my pandemic briefs, which means not only is the research and the arguments mine, but also the typing. So to the extent that there are errors and typographical errors, those are mine and should not reflect on my staff in any way. I would also note one embarrassing typo is I refer to the Preeb case as being in some places as can app as opposed to can app second. And I apologize if that caused any confusion for the court or for its clerks. In this case, the record and the briefs are extensive, and I'm going to try and simplify my arguments just to the matters that I think are controlling and result in sustaining the order of the Board of Tax Appeals. This appeal was filed while the matter was still pending at BOTA. While BOTA was considering a petition for reconsideration filed by Arciterra, the appellant filed this appeal. BOTA subsequently issued an order on reconsideration, and no appeal was filed subsequent to that. Appellee did file a motion for an involuntary dismissal. That was denied, but we simply ask that the arguments raised there be considered by this panel.
Well, and since you have not filed a cross appeal, we likely will not address that issue. And
Okay.
Normally premature notices of appeal are fine. So I think if we could move on, it would benefit all of us.
I wish the administrative law mirrored the civil procedure. It would be simpler, but it didn't in this case. In any event, here's my the arguments I think that control the ruling here is the issue of burden of proof and what BOTA decided. Neither party disputes that the appellant had the burden of proof at BOTA, and nobody disputes that there's no preference which exists in favor of the county. And while the order doesn't specifically state that the appellant county failed to carry the burden of proof at BOTA, the net effect of the order is that conclusion. The appellee relied exclusively on the opinions developed in the appraisal by Gerald Mayer, an MAI with mainland valuation. And the county relied exclusively on the opinions of value in the Keller appraisal, which is Mr. Keller was the outside expert retained by appellant. So what did BOTA conclude? Well, first they concluded they were bound by Kansas law and published appellate precedent, and held their task was to find the value of the fair market value of the fee simple interest in the real property. Secondly, they concluded, in their opinion, the income approach was the preferred method to get to that value in this case. And third, as to the credibility of the experts, BOTA rejected all of Keller's analysis because BOTA concluded the Keller report violated the clear directives of PREB. It also found it had limited information and was of limited probative value to BOTA in deciding the case. On the other hand, they accepted Mayer's opinions because his analysis and appraisal did comply with the directives of PREB, and his conclusions were supported, as they said, by 9 lease comparables, 7 of which were in Johnson County, and that those were comparable in generally to the subject property with respect to the age and size of the building. But the findings of BOTA as to the credibility of the experts does not seem to be reversible on appeal. So did BOTA find the fee simple value, or as appellant argues, a hypothetical lease fee interest? Well, the BOTA summary order and their full and complete order are clear. BOTA knew Kansas law required them to value the property in fee simple. That's KSA 74-2433. And 74-2433 was amended in 2016 to include this requirement that BOTA find property values in fee simple. And that's significant because the 2016 amendments followed the 2012 PREB case, which defined fee simple. I think it is a fair assumption that the legislature was aware of the definition of fee simple in PREB and effectively endorsed it in the amendment to 74-2433. I would note that the PREB definition of fee simple has been cited by the Kansas Supreme Court in 2017 in the Cregan case for the definition of fee simple. Cregan is not a property valuation appeal, but it does cite to definition of fee simple to PREB. So to me, the definition of fee simple is clear, and the requirement to value property in fee simple is also clear. The confusion, it seems to me, is caused by Mayer including in his appraisal report values of the fee simple interest and of his hypothetical lease fee. The record explains why he did it, but the why is really not relevant, as the appellant and the appellee, BOTA, the taxpayer, both appraisers, everyone agrees that the fee simple is the proper interest to value. Even though the appellant county does not agree with the definition of fee simple in Cregan, the appraisal of real estate, or the dictionary of real estate appraisal. Appellant is stated here prefers the Black's Law Dictionary definition, which quite frankly, I don't see much difference between the two. In any event, I would argue there is simply no reason in a property valuation case to go to a legal dictionary when we have a perfectly good definition of the appraisal term in the appraisal of real estate text in the dictionary of real estate appraisal. So BOTA makes a specific finding that it must find a value in fee simple, but then finds that the value Mayer concluded in his hypothetical lease fee better represented the value of the fee simple interest.
And the problem is that even in Mayer's testimony and in his report, he distinguishes between his fee simple assessment and his hypothetical lease fee assessment, which would lead one to conclude that the hypothetical lease fee is not the pure fee simple interest that the law requires us to assess.
I agree. And he didn't state that that was his opinion of value for this property. The appellant or the taxpayer didn't ask BOTA to do that. And I don't think BOTA found that. Here's what I think BOTA did. I think BOTA said, look, we have to find a value in fee simple. Mayer has 2 numbers. We like the value, we know we have to be fee simple, but we like the number he arrived at in his hypothetical lease fee. And here's why I think that that's correct. Because one, it is the only way to read the order and have it make sense. Because if you say that BOTA acknowledges they have to follow Kansas law, that Kansas law is fee simple, but then for some reason, without any explanation, we just decided to do something else. Secondly, in support of this, if you look at Mayer's work product in his, just in the income approach, his income approach for the valuation of the fee simple interest and his income approach for the valuation of the hypothetical lease fee. The only difference between those two is the cap rate. You can see this from the record volume 1, pages 47 and 61. So in his
Did you say cap rate?
yes, his capitalization rate is the
Okay.
only
All
difference.
right.
The
It kind of cut out here, so I just wanted to clarify.
yeah, sometimes I talk too fast. I'm trying to stay slow, but
That's
it's a
fine.
horrible habit. In the in both approaches, but whether he was valuing fee simple or hypothetical, the net operating income is identical. In other words, he used the same rent, the same expenses, the same vacancy and collection loss, but he has a different cap rate based on the risk of the property between fee simple and hypothetical lease fee. So what BOTA could have done is they could have said, we're adopting his analysis in total, or in his we're adopting mayor's opinion in fee simple with one exception. We're changing his cap rate. This happens all the time. I think that would have eliminated the confusion that they caused. But I don't think you can conclude that BOTA is saying in their order, we're bound by the law, we know it's fee simple, but then without explanation, we're going to attempt to overturn established law by valuing some interests that we just said we weren't going to do. So I think the proper thing is that you can say BOTA adopted his opinion, but they just simply changed the cap rate. And could I just say at this point too, the reason that PRE rules out using build-to-suit rents is because build-to-suit, we're trying to find a market rent, and build-to-suit leases are never exposed to the market. This is a financial arrangement between the developer or the owner and the property occupier, where they're going to be a tenant or maybe they'll buy it. But that is all done before they even dig the dirt. No one else is competing or suggesting a different rent. So it's not, in order for you to find a market rent, you must find that the rent has been exposed to the market and that the market has determined the rent. This is just financing, as Judge Schroeder said, and I believe that is why PRE reads the way it reads. I would also say that as to the many points that are in the Appellant County's brief, many of them are just not issues in the case. Most of them are really not tied to any part of the record, and seemingly to appellee are irrelevant to the determination of the case. Because appellant seeks to overturn PRE and other established law. But as this court said, in the matter of Cessna Employees Credit Union, from an order of the Director of Taxation, which is 47 Canap 2nd, 275 in 2012, a case that arrived at this court under similar circumstances. There, the Director of Taxation argued, you were wrong and you need to change your interpretation of the law. But this court stated that the law had not changed and that appellant's disregard for the way this court has interpreted the law should be addressed only to the legislature and not by a return to this court repeatedly hoping for a different result. Appellant in this case is in the same position as the Department of Revenue in the Cessna Credit Union case. Their remedy is with the legislature, if anywhere. So in conclusion, the property tax is just that. It's a tax on property. It's not an income tax. It's not a sales tax. The economics of the owner are irrelevant. And this court has been clear that the property interest to be valued is the fee simple estate. And that interest is defined by the appraisal of real estate, the text, and in several Kansas appellate cases to be the full bundle of sticks, subject only to the 4 powers of government. What appellant seeks is for this court to create a previously non-existent property right they call fee simple subject to a lease. This fictional property interest is just the lease fee estate renamed. And the law is clear, I've cited to a number of cases in my brief, that Kansas is a fee simple state and not a lease fee estate. So in conclusion, BOTA orders are to be sustained if they're supported by substantial and competent evidence and correctly interpret the law. They were. What appellant seeks is for this court to reweigh the evidence, to reweigh witness credibility, all while faulting Boda for following Preeb. I don't think we can reverse a decision of the Board of Tax Appeals because they followed a law that appellant doesn't particularly like. And I would say, I'm not sure what the issue with the closing was from the county. I just know that the board order reflects that at the time they considered the decision, that the only findings of fact and conclusions or closing argument were from appellee. Whether they were and filed or ultimately added to the record, to me, is irrelevant to the issue of what Boda said. Boda said when we decided the case, we didn't have that. The appellant did not ask for a petition for reconsideration, did not file, or if filed, board didn't know they did because they didn't consider them filed at the time. So with that, all of that, I would ask that this court sustain the order of the Board of Tax Appeals. And if in fact the court determines that maybe Boda was finding a value in hypothetical lease fee, it seems to this party that their only option would be to remand with directions that they adopt mayor's opinion of value and fee simple, because they've already rejected Keller's analysis in total. So I appreciate the time. Thank you very much.
Thank you, counsel. Mr. Carpenter, you have 5 minutes.
Sorry, Judge Gardner, it took me a minute to unmute there. I think I can be fairly quick. By appellee's own admission, Boda did not say that the county failed to meet its burden. One can certainly look at the decision and possibly suggest that that was the case. Under 79-503A, which defines fair market value in the state of Kansas, paragraph G suggests, and this goes back to the fair market argument, that you can look at the earning capacity of the property, including leases in place, as a consideration. It's not the only thing, but it's one of many factors to be considered when valuing a property. The only hypothetical condition in that statute that defines fair market value in Kansas is that the sale happened on January 1st. There is no suggestion of a hypothetical lease fee. The hypothetical lease fee is based on moderate credit tenants, 2 to 3 year leases. These are not the type of these are not the type of tenants that are attracted to these properties. Taxpayer Council stated that Boda found that mayor's comps were better. That again, erroneously or misinterpreted the law, because that does not comport with generally accepted appraisal standards, which suggest the best comps are highest and best use. Mayor's properties were older, they were smaller generally, and only 2 of them were freestanding retail buildings. Most of them were inline buildings. That is not the same highest and best use of subject property. In fact, in the appraisal real estate, the highest and best use analysis is considered by some appraisers to be the heart of the appraisal. Again, even though Taxpayer Council points to 74-24-33, which inserted the language fee simple, the county would suggest that that's not defined in that statute, and the legal definition controls. As to Taxpayers Council's suggestion that if this court finds that the valuation should be remanded and ask for a lower value for what she referred to as fee simple value, the county would suggest this property was not cross appealed, which bars the appellee from arguing from a lower value at this time. And Preeb, as you will see in the future and has been argued in other cases, the Preeb case has a tenuous basis in the law as it stands today. For example, a case that was cited repeatedly is 311 Wisconsin 2nd, Walgreens versus the City of Madison. That's easily distinguishable from this case. In that case, The state of Wisconsin had a manual that told appraisers how to value property. It stated that they were going to use market rent, and the assessor in that case used contract rent that accounted for super adequacies. No side suggested that this subject property has any super adequacies. Moreover, Preeb also relied on two cases from the state of New York, a matter of Eckerd versus Buren, 83 AD 3rd, 1239, 920 New York South 2nd, 824, and matter of Rite Aid, New York versus Assessor of Town Colony, 58 AD 3rd, 963, 87 New York South 2nd, 2009. These cases have been overturned by subsequent cases, meaning that the cases upon which Preeb was founded aren't even good law in some states anymore.
Does Preeb still stand as law in Kansas?
It has not received any negative treatment that I am aware of, Judge Schroeder.
So then are you asking us to make a determination different as another panel of the court from Preeb?
To a small extent, yes, but moreover, the county's position is that there was that in this case, when it went to the market and looked at build to suit leases, that those didn't include any super adequacies. They were not financing agreement because no inventory was financed, no FF&E was financed, no cash advances were given to the tenant. So that in essence is the market, Judge Schroeder, and there is no necessity to disentangle. You only need to disentangle when it's appropriate. It does not seem to be appropriate in this case. This was not a financing agreement as Preeb contemplates. And moreover, again, the county would rest on the position that the whole aspect of what constituted disentanglement of the rights was beyond the scope of the appeal in Preeb. And back to, I want to make sure I hit on it. The highest and best use, the comps, the sales, very few of them in Mayor's appraisal were the same highest and best uses of subject property. The Keller appraisal, the county's, was much closer in highest and best use of the property. That constitutes a misinterpretation or misapplication of the law. In fact, it's arbitrary and capricious to base a decision on an appraisal that does not use comps that are in the same highest and best use classes of subject property.
Mr. Carpenter, your time is up. Would you like to make a short summary?
No, other than, Your Honor, the county would respectfully request that this county be remanded to BOTA for further consideration of the proper fair market values defined in 79503A for the tax years at issue. Thank you for your time, judges.
Thank you to both counsel for your arguments and briefs. We will take the matter under advisement and get you a decision when we can.
All right, thank you very much.
Have a nice day.
Thank you.
Stay safe.